is in regards to their probationary status or their status as a parolee, which means once they're out of prison, they're on parole, so they're in the community on supervision, or if they're on probation, it means that it's an alternative to incarceration. They're allowing the guilty person, once found guilty, to be in the community under the supervision of a probation agent. So there are certain cases that apply to certain rights of either the probation person or the parolee. One such case is Griffin versus Wisconsin, which was decided in 1987. Now you may recall that if you are just an average citizen going about your business, that the police cannot just come to your house and say, "Excuse us, we're coming in and we're searching your house." You probably have learned that the police have to have probable cause and apply for a search warrant in order to search your home. And that is because the courts have decided that a private citizen should be safe within their home, and the only time law enforcement is allowed to search a person's home, which has been referred to as their castle, is if they have that search warrant. But when you are on probation or as a parolee, you have limited rights because you have been granted this privilege of being in the community while under supervision. In this case, the Griffin case talks about whether or not a probation agent or parole officer can search a probationer or parolee's residence without a search warrant. So, think about that. Do you think that's appropriate? Should an agent, a probation agent or a parole agent, be able to come into your home if you are on supervision and just start looking around? Because if they find anything, they can use that against you. So should they be able to do that? Well, that was the whole point in the Griffin case. And that decision was based on, because you have this privilege of being in the community, you don't have all the necessary rights of a private citizen. But they also said, maybe an agent doesn't have to have probable cause, but they do have to have reasonable suspicion. They have to have a reason as to why they would search your house. So, let me give you some practical examples. Knock on the door, it's your agent. You let him in, you have him sit down at the couch, and the agent looks over, and right there on the coffee table is a marijuana pipe. Well, that's in plain view, and that now gives the agent reason to believe that you might be violating the rules of probation. So what they would most likely do is call police. The police would come just to secure you so that you cannot interfere with the agent's search. Then the agent could search throughout the rest of your house. Now, when I gave that example, most of you were probably thinking, well, that sounds reasonable. That doesn't sound offensive to anyone. And you were probably also thinking, boy, that person's pretty stupid to keep a marijuana pipe out in plain view. But that's beside the point. The whole idea is that an agent can come in with reason and search. But what the Supreme Court really emphasized is that given this ability of an agent to search, that they couldn't be used as just like this a group for law enforcement to use. For example, the law enforcement has a higher standard. They have to show probable cause in order to get a search warrant. But let's just say they've gotten some information that indicates that the person is doing wrongdoing. They can quick call the probation agent and say, hey, this is what we're hearing on the street. Now that's enough reason for the probation agent to go into the house, but not law enforcement. But what the Supreme Court cautioned was police can't use the agents. See, the agent actually has to go and do the search and gather the stuff, and it's based on a reason. So law enforcement can't just be lazy and say, well, we got a little information, that's all we're going to do is just keep letting the agents do it. They would have to build up their case and get a search warrant before law enforcement could actually come into the house and search the house. But they can assist the agent, like I said, making sure that you, the probation person, doesn't try to interfere with the agents doing the search, and can actually take you into custody. But that custody is because the agent has directed law enforcement to keep you in custody. Another case that talks about rights of a person on that community supervision is Morrissey versus Brewer, and that was decided in 1972. Now, you understand that when you are on a sentence where you were sentenced to prison, after a period of time when you're released from prison, there's this time that you're on this community supervision called parole. When you're on parole, you have strict rules, and your parole agent will set up certain rules for you that apply to you directly. You are required to follow those rules. Now, before Morrissey was decided, what happened is if a parole agent thought you broke a rule, they would say, hop on in the car, and they would drive you up back to prison. And that was it. You'd go back to prison to finish out your sentence, just based on the agent's word that you violated your parole. Well, this case started out with someone complaining, saying, I think I should have due process rights. And the court agreed. So from that decision, what happened is if you were suspected of violating your parole rules, there was a regular hearing that was held. Now, this isn't in front of a judge. This is in front of an administrative law officer, sometimes referred to as an administrative law judge. And they would hear the testimony presented by your parole agent, and you would have the right then to cross-examine witnesses or even present witnesses on your own behalf. Remember, prior to this case, that never happened. And the second part is that you would have a right to the written allegations, and once a decision was made, you would have the right to a written decision. And if that decision said you did violate the rules, then you would go off to prison. If the administrative officer or the administrative law judge would find that you didn't violate your parole rules, then you would not go off to prison and you would remain on parole.